I had said, well, I don't want to have anything more to do with the defense side, and I switched entirely in 2001 to pure plaintiff's work.
So I have been incredibly lucky to land at a place on the right side where I believe in the work that we do. I get to work with an incredible, talented, dedicated group of individuals. There are a lot of them sitting in the third row here, so you should say hi to them later.
The plaintiff's bar covers nearly everything, and there is a way to find the thing that you are most passionate about and still get paid.
Everything you're feeling is real, and it does lead to a career path, but it also leads to a career path that you can keep on changing, and you can keep on delving and testing with, and that's totally fine.
I decided to become a plaintiff's lawyer the day I found myself in a cigar smoke-filled conference room at Kirkland and Ellis's New York offices with John Bolton. And I realized I'd made some poor choices.
We always out-lawyer the other side, always. And if we don't win, it is usually because of a judge or jury issue or some messed up part of the law, and not about the lawyering.
You can be creative on this side. You're destructive on the other side. Do you want to create, or do you want to poke holes in something and make it collapse?
We're litigating against all of those defense firms, and we're winning against all of those defense firms.
It's not big law that is suing the opioid manufacturers and distributors and the pharmacies.
And the law is set up to make sure that the remedies in these cases are not justice. They are set up to be less than what would make someone fall, to be set up to be less than what would change the system.
It's a really imperfect system that favors corporations.
Plaintiff's work is, I think, it introduces back into the work that we do the concept of justice. And the creativity is identifying people who have been wronged or companies that are doing wrong and figuring out solutions to actually introduce that concept in different forms back into the law.
I'm working from the bottom up. We're street fighters, and we're working to find justice where we can, but we have to meet those defense firms where they are.
If we want to think about justice, it needs to be joined with something that's outside what the current scope of the law is. Because the current scope of the law can't do that. It's not set up to do that.
We've really tried to learn and learn how to think like a captured corporate judge.
We had legal writers looking at this. We had organizations like Public Justice and AAJ and others who were starting to agitate. We had plaintiffs' lawyers who had victims who came forward and told their stories to Congress. And finally, in March of last year, President Biden signed a bill that banned forced arbitration for sexual assault and sexual harassment cases, which was amazing.
Things changed as the epidemic grew, and we were able to get in front of a judge, and that judge could begin to identify with what was happening in his or her community.
What we're seeing today is a concentration of power in corporations that really is an expression of a lot of the ills in the United States, and that's a way that makes a lot of the litigation yet more satisfying.
There are numerous plaintiff-side organizations, and nearly all of them have student memberships.
Get outraged and then do something about it. That's what we do on this side.
I want to just dive straight into the questions because I know we have a limited amount of time and everyone here is super excited to hear what you have to say. So, for starters, we'd love to know a little bit about your career path. Many see big law and corporate defense practice as the default for law students. And certainly it's the path of least resistance. So how did you end up on the other side? And Lauren, I know you spoke about this a little bit yesterday, so I was wondering if you could get us started.
Sure. Thanks, Pranay. My story is very short and very lucky. I was introduced, hi, Madeline. It's my 7-year-old in the back. I was introduced to my then boss, now partner, great friend, Tom Sobel, while I was thinking about going to law school. And when I was thinking about going to law school, I was going with the express intent of not being a lawyer or not being a practicing litigator or lawyer of any sort. I was going because I worked at the time with Tony Shays, who was at the Kennedy School of Government, Martha Minow, who was and still is here, and other academics who were doing conflict resolution work internationally. And I thought everybody who's doing the cool stuff has a law degree. That's the language I need to be able to speak. So I went to law school, or I went into the application process with the explicit goal of getting that education and then rejoining out of that community that was doing nonprofit conflict resolution work internationally. And in my first year, after having met Tom, I thought, well, maybe I should try this. Maybe I should give it a go. Several people said, just ask Tom for a job. So I asked Tom for a job, and he said, I will make you work really hard, and I won't pay you very much, but you are going to learn a ton. And that was my first, it was a summer between 1L and 2L year, and I haven't left. So I have been incredibly lucky to land at a place on the right side where I believe in the work that we do. I get to work with an incredible, talented, dedicated group of individuals. There are a lot of them sitting in the third row here, so you should say hi to them later. And to spend my time working there in that community doing work that I think is important, and then hopefully encouraging more students like you to do the same thing.
You like to go?
Sure. Good morning, everyone. Jayne Conroy. It was a really long time ago. You're bringing back memories of my early days, but I was going to be pre-med. I was pre-med in college. Everyone in my family was sort of in the medical world. I don't think I could have told you when I graduated from college who was a plaintiff and who was a defendant. I confused them all the time. And I graduated from Dartmouth. I was applying to medical school, and the day after I graduated, I had a very close friend whose dad was a lawyer in Boston, and he had just, and everyone here, most of you are too young to remember the diethylstilbestrol cases, DES, which was a drug given to women to prevent miscarriage. And he was a defense lawyer in Boston, and he had just picked up a client in those cases, and he said, come work for me for the summer, figure out where you want to go to medical school, but I really need someone with a scientific background to help me navigate this case. Well, I started, I think by my third day, I was totally hooked. I loved the law. I said, I never want to work in a hospital. I don't even know why I was thinking that. And ended up, the case was crazy busy, worked round the clock, did not make much money at all. In fact, still was waitressing on the weekends because I was not making very much money. And ended up applying to law school at night here at New England School of Law. Couldn't afford to take the time I needed to make a living, and kind of ran that gamut of defense work for about 15 years. Had some very big defense verdicts here in New York, and was asked to move to here in Boston, and then asked to move to New York for a very large defendant, international defendant. And when that defendant finally went into bankruptcy, which was really my largest client, I had said, well, I don't want to have anything more to do with the defense side, and I switched entirely in 2001 to pure plaintiff's work. I had always tried one or two catastrophic plaintiff cases during my defense career, but was very happy to switch over entirely, and began my plaintiff career suing Purdue Pharma for OxyContin, which was just a brand new drug at that time, and had lots of really amazing cases to work on. My firm, my department, with all of my lawyers, we've just been working really hard for years, but I think really making change. Maybe we'll talk about that a little bit, but it was not a hard decision to switch, but it was difficult financially to switch from defense to plaintiff's law.
Anna, would you like to answer next? And then we can just sort of go down.
Sure. Hi. It's really nice to see all of you, and I've had so much fun talking with a few of you that I've met so far. So I graduated from law school. Well, I went to law school with this idea that law school was going to be a way for me to understand more about American history. I was a history major in college, and I thought it was so cool. And then I got to law school, and I was like, whoa, this is not really what I envisioned in this like glorious sort of idealistic head of mine at the time. And the career office, turning away from like learning about history and focusing on like what do we do next, the career office, at least in my opinion, and Matt and I went to school together, so he might have some thoughts on this too, there was an option of go to a big defense firm in New York City or work at a nonprofit. And there wasn't really a middle ground. And still, not having rid myself of all of the idealism and faith in the law and Constitution, I was like, okay, well, I think I will go work for the government instead, because that is something in the middle. And I had this strong sense of patriotism. So I went to work for the Department of Education's Office for Civil Rights. It was not a litigation job. It was a policy job. And as you can imagine, during the Bush administration, the Office for Civil Rights had very little to do with actual civil rights. And I wasn't thrilled about DC, so I decided to move back home to Minnesota, and I started networking like it was my job. And then I met a lawyer who knew my now law partner, Steve Smith. And I remember interviewing with him, and he was just willing to take a chance on me, and I've been there ever since. So my firm is based in Minneapolis. We have an office in San Francisco. We have 35 attorneys, 30 staff. We do no mass torts. I know there was a big focus on that yesterday. We do not represent corporations. We sue corporations and the government. And in my time I have worked there, I have done minimum wage and overtime cases on behalf of marginalized workforces, done consumer protection cases on behalf of other marginalized groups as well as student loan borrowers. I have sued the United States under the Federal Tort Claims Act for treatment of indigenous women. I have done a whole bunch of stuff, and I'll collect my thoughts so I can talk more about them later, but my point is that the plaintiff's bar covers nearly everything, and there is a way to find the thing that you are most passionate about and still get paid. We're a private firm. We have to pay those 35 attorneys. We have to pay those 30 staff people, and so any information that you have been sold about how it is not possible is false. It is hard, and we'll talk about why it is hard, but there are options out there, and I'm excited to talk more about them soon.
Thanks. To maybe put my career path in kind of affirming some of the things I heard yesterday, I feel like your experience was what you're describing as your experience is very similar to kind of where I went through in law school. I came in with a master's degree in refugee studies, and much like Anna thought I was going to do that kind of work, and got quickly dissuaded in law school that there was anything like international law that actually could be done. And law school took over with the fear, and I think that description of fear felt very real. I spent a summer at Paul Weiss because of that fear. I actually don't regret that incredibly, because it taught me I didn't want to do it, but I also want to affirm that if that's where you're going, there's a reason that's where you're going, and it's okay. There are ways out of that too if that's where you decide to go. And after that, I clerked, and I started on the nonprofit merry-go-round, and several of you talked about that nonprofit merry-go-round, and that also is real and scary, right? So my first job after clerking was for 1 year, And then I immediately needed to start finding another job. I went to a plaintiff's firm in part because of the security, and I do think one thing that nonprofits are not good at, but that plaintiff's firms are, is security. There's much more security there, and that's part of the reason I switched. I went back to a nonprofit, but was told immediately when I got started at a nonprofit, we have grant funding, and when this expires, you're gone. And thankfully, it hasn't expired yet, although the nonprofit still hasn't paid my salary, right? We keep on finding other people to do it, so maybe we'll get around to them forking up one of these years. But that also was scary, right? And I will say also the money that plaintiffs' firms afford allowed me to make that jump. And I love my job. I think it's wonderful. I think that it lets me think about both litigation and movements at the same time, and I hope we get to talk about that more, because I think there's a way to join a lot of what you heard as the goals yesterday into one practice, which I think the nonprofit world goes through. But everything you're feeling is real, and it does lead to a career path, but it also leads to a career path that you can keep on changing, and you can keep on delving and testing with, and that's totally fine.
I decided to become a plaintiff's lawyer the day I found myself in a cigar smoke-filled conference room at Kirkland and Ellis's New York offices with John Bolton. And I realized I'd made some poor choices. And I think I agree with David that your career arc and all of our career arcs, as you can tell, are not linear, and they don't take one direct line, and you don't necessarily find the right place with the right people the day you graduate from law school, the year after, 2 years, 3 years, 5 years, 10 years down the line. And it took me several years to realize the kind of work I wanted to do, the kind of people I wanted to work with. And once I realized that, once I had a vision of a life, a professional life that felt authentic and genuine to me, then it became a question of figuring out, okay, that's the kind of thing I want to do. How do I take the steps to actually get there?
Thank you for sharing how you ended up on the plaintiff's side. So we had a panel yesterday of students, and they spoke about a perceived binary between working for traditional public interest positions, maybe a nonprofit or a government agency, or for big law. Perceived sort of decision between being forced to work to advance their values or to pay off their debt. How does plaintiff side work challenge this binary? And Anna, you were speaking about this a moment ago, so I was hoping you could take the lead on this.
Yeah, I didn't know that firms like mine existed when I was in law school for many of the same reasons that you all have talked about and that we've heard about over the last day and a half. But there are many, and I know Lauren addressed a little bit of this last night, but there is a misconception that it's just 2 or 3 large firms that do mass torts. There are numerous plaintiff side organizations, and nearly all of them have student memberships.
The Camp Lejeune case that you're hearing all about, and all of these complaints about, oh my God, all these ads. Well, guess what? That camp spewed benzene out of the bubblers at the elementary schools, of which there were 8 on that camp for 40 years. There are a lot of people that were injured by the chemicals at that plant, at that camp. How are you going to reach them? The Navy isn't writing letters to everyone that lived there and said, hey, check out, if you've got cancer, maybe you should look at what was happening at the camp. That's on the plaintiff's bar in our private firms to advertise for those cases. So keep an open mind when you hear about these types of things and why they're so awful, that they're completely necessary if we are to affect change and compensation. Justice, it's a hard word. I don't know how you give justice to somebody that's been injured, but maybe you can compensate them. So those are some of the misconceptions, and there's a reason that we need to keep an open mind when we hear about them.
Can I add a couple things? I think Jayne's totally right. I also think, we heard a little bit from, I think, some of the students yesterday there's this feeling like plaintiffs' firms are somehow less prestigious than, the corporate defense track. That, if what you want to do is, is work that will be well respected, and, people here, HLS and any of the other law schools, that's always kind of ever present is, you're all high achievers. How can I continue to be a high achiever and be respected in my profession? And certainly when I was coming out of law school and when I started thinking about plaintiffs' work, that's what I thought. I thought, oh, well, to be respected and to reach a certain, level in my career, I need to go to a place that is respected, and that's like a corporate defense firm, and they're all over the place, and that's what they're selling, and you can really kind of be convinced of that when you're in law school. But everybody up here and everybody in the audience, all the plaintiffs' lawyers here, we're litigating against all of those defense firms, and we're winning against all of those defense firms. So the work is better, but the level of advocacy and the level of lawyering that you're seeing from Hoggins Berman, from Nichols Castor, from Jayne's firm, from Public Justice, it is frankly actually well beyond the quality of the advocacy that you see on the other side from pick your defense firm that you think is like the most prestigious place that you can be. And so I think there is this idea that gets kind of takes root very early, in law school, because you're seeing these firms on campus and you're going to these events and people are getting these offers. And, if you look at like the career arc of, someone that is out there, judge or something, you'll see that like, oh, well, they, spent, time at Paul Weiss, or they were at Williams and Connolly or whatever, and then they went on, and that's the career path. But if you actually dig in and you read like the briefs that are being written by plaintiff-side firms, if you're looking at the advocacy, seeing the wins that they're having, and you're looking at who's on the other side, what you're seeing is actually the prestigious place to be, the place that's actually higher in terms of advocacy, it's actually on the plaintiff side. And the more that you can kind of get out of the mentality of thinking that the defense firms are really the prestigious path to be taking, I think the easier it becomes to envision yourself doing the work that is really going to be driving how you feel about your career.
Yeah, I agree with that 100%. I feel like I frequently say, and probably said to some of you yesterday, we always out-lawyer the other side, always. And if we don't win, it is usually because of a judge or jury issue or some messed up part of the law, and not about the lawyering. Defense firms, they get paid by the hour, whether they win or lose. While we pay all of our associates and employees, their regular salary, the firm, the partners, we don't get paid unless we win. The firm doesn't make money. And so there's this incentive to not only work hard, but work to be the best, because you need to do everything you can do, not only to make the firm profit, but because your cases are real and the people are real. Like, these are real human beings. One of the misconceptions that I heard the other day was the sort of quick settlement that doesn't help anybody type thing. There are so many rules, and this is part of corporate capture also. A defense lawyer can walk into a room, do a dog and pony show to a corporation or a beauty contest and get a client. We're not allowed to talk directly to clients. There are rules prohibiting that. We can't direct solicit anybody. Similarly, in settlement, we can't just agree to a settlement. The client has to be there. The client has to give authority. Class actions go through 2 court approvals to make sure that there isn't anything shady about it. So it's a really imperfect system that favors corporations, and I could talk to you for hours about how every rule of civil procedure is super messed up. Like, why do I have to give a corporation notice of the topics I'm going to depose them on when they don't have to give my client any heads up on what they're going to ask? But it's figuring out a way to work within those constraints to make real change. And the things that Jayne was talking about are real, because in nearly all of our settlements, we ask for injunctive relief, not just money. There's a case on appeal at the Fourth Circuit that I brought with Lambda Legal where we won affirmative summary judgment that the state's refusal to cover gender-affirming care in their Medicaid program violates the law, and the relief is injunctive, meaning they have to take down that bar. That helps everybody in the state. Anyway.
I would just, the injunctive relief is so important. In the opioid litigation, we recovered, obviously, money for the communities, but alongside that is injunctive relief going forward in time, and attorney generals are keeping an eye on it. Some of the companies have monitors, and it means that they cannot continue to break the law, or we hope that they cannot continue to break the law. And we have also forced them to produce and make transparent all of their documents, which means you get to see what's behind with respect to clinical studies and other information. We are not always successful with that in litigation, and here we were very successful, and it becomes a precedent for future litigation. But releasing documents to academics and such, and journalists to write articles is a huge way to change, to make social change.
Can I just, I want to emphasize what the kind of combination of Matt and what Jayne was just stating about the changes that are being made. I don't think we can say enough. It's not Big Law that is suing the opioid manufacturers and distributors and the pharmacies, right? It's Jayne's firm and, I don't know, like 7,000 other plaintiffs' firms in the country. They're the ones who are getting this money released to communities to try to stop and abate the harm of this opioids epidemic, which is the health crisis of our generation, right? They're the ones who are getting the documents released. It's plaintiffs' lawyers, it's not Big Law who are suing about data privacy issues, right? It's plaintiffs' lawyers, not Big Law, who are suing about cars spontaneously setting on fire when the car company says, well, we don't know what to do about it yet, so just don't drive it and don't park it near a building, right? It's not Big Law that's bringing those cases and trying to get that changed. It's plaintiffs' lawyers. Running through a couple of other quick, the misconceptions everybody hears that we've already kind of touched on. There's tons of frivolous cases out there that the plaintiffs are bringing, right? They're looking for the quick settlement, as Anna pointed out, and Jayne pointed out, we don't get paid unless we win, right? I don't want to bring a frivolous case. Why would I do that? I want to spend my time and my effort on a case that I think is worthwhile, where I think I'm going to affect change and I'm going to bring in money for my firm, right? And money for my clients. There's this double one that I think is interesting. Plaintiffs' lawyers are only fat cats, right, who fly private jets and they're getting all the money from all these cases. And also, you can't get paid doing plaintiff's work. I'm not sure how those go together. Yes, there are people who have been extraordinarily successful on the plaintiff side who do have private jets. There are a lot of those on the defense side too. Anna, are you pointing out you're one? No, Anna's not one.
I drive a Dodge Stratus.
Exactly. You're not helping with my second one, Matt, which is that you can and do make money. He might drive that because he's got 2 kids. He's taking to soccer. There you go. Right? You can make quite a lucrative living on the plaintiff side. You have to have a little bit more risk tolerance, right? That's the difference. We're trying to figure out how you fund a firm and you pay these extraordinarily talented people that you've brought in to do this incredibly important work, and you might have to fund it for years and years, right? And you're putting in your own money to pay for those experts and to do that work. And yes, then if you are successful, you get to reap the benefits of that. You're not always going to be successful. But if you've got a well-managed firm and you've got partners who are thinking about this, it's entirely possible to live very well on the plaintiff side. The last thing I will say is I have never chased an ambulance. When I hear those sirens, I pull over to the side.
I would also say one other thing, that when you work with a whole bunch of risk takers who are willing to put it all on the line, it's a way more interesting group of people.
Well, I actually wanted to pick up on that because this was something that came up yesterday, and I want to underscore 2 things. So Molly talked about fun, and I want to emphasize, right, when you're with a community, when you're with a person or a person who's been harmed, and you are thinking about how you can get them right, how you can advance their story, how you can uplift and move the world slightly in where they want to go. It's not always fun in that it's, right, sometimes there are real harms there, but it's always very rewarding. And that's amazing to feel on a day-to-day basis, but it's also immensely creative, right? I do think the one thing I heard yesterday that I think it was just wrong was that litigation's not creative. Litigation's immensely creative, right? You have to figure out standing, you have to figure out remedy, you have to figure out your cause of action. I have a line of First Amendment cases where there's ALEC, the American Legislative Exchange Council, writes a new bill every time we win, trying to figure out how to keep us out of court, and we have to figure out how to get back in. And that's a lot of fun, and it's creative, and I actually will say also one other positive, you're learning the right things in law school for that. There's some criticism of the bedrock things in law school. I actually think you need those bedrocks to be able to do that fun creative stuff, and so you're at the right place to be able to take the next step. But it is a really good experience.
I want to give an example of something super creative because it overlaps with this idea of systemic change and taking down corporations. And I use this example a lot because it's a real case that I had, and so some of you have already heard it, but also it just really hammers home the point about creativity. So there is a theory of law called disparate impact. I don't know if you study it in law school. I certainly didn't. But the idea is that you find a facially neutral, I'm using air quotes, policy that a corporation has that has a disproportionate effect on a protected class of people. And that is how the case works. You don't have to show intentional discrimination. So here's an example that I've talked about in a case that I've brought before. There are some companies that do background checks on people before they hire them. What if the company's background check criteria included making sure that you didn't have too many points for violations on your driver's license, on your driving record? Well, okay, great, that's the company's policy. But who's accruing points on their record? Who is getting stopped just for driving their car? And that has a disproportionate effect, right? Like you can use public data and prove, and this is, it just makes sense once you start thinking about it, that people of color are being stopped at a higher proportion. So they are accruing points on their license, and that has that policy of hiring somebody who doesn't have points on their license has a disproportionate effect on that protected group. And so that is a type of employment claim that you could bring that is super creative. So I don't know, I agree, there's just a ton of stuff that you can do that might not automatically dawn on you, but once you put your plaintiff's lawyer hat on and start thinking, there's a ton of stuff out there, and there are tools that we can use to move the needle away from corporate culture.
Well, that's very true, and we spend years sometimes trying to refine theories so that we can bring a viable case. Back in 2001, we sued the sponsors of terrorism after 9/11, and we had difficulty finding a theory, and we just sat in a room with a number of other plaintiff firms, and we used a Piracy Act from the late 1700s, which was very effective and is being used right now. It was hinted at in the Lockerbie case, and then we were able to sort of really close the loop with it in the early 2000s. In the public nuisance arena, opioids has likely changed what we're going to see happen with public nuisance going forward. It's also going to change and create a real dynamic that all of you are probably going to experience in your careers about municipalities suing for things like that versus states, which is a very big issue. Not sure how that is going to come out because there's a lot of tension between a community bringing a lawsuit versus the state on behalf of a community. So every time when you get into this complex litigation, at every turn, there's something you need to be creative about because it's not easy. It's part of the attraction. You're always trying to figure out how to get yourself to a place where you can have a case that's upheld.
Can I just want to, both those comments made me kind of think back to something that John said yesterday in his conversation with Noam, and I thought it was a really powerful point that he made, which is, this, and when you get to law school, there's this kind of erasure of justice. It's on the wall of the building, and then you walk into the building, and it's nowhere to be found. And what you're hearing, what Jayne just said and what Anna just described, the plaintiff's work is, I think, it introduces back into the work that we do the concept of justice. And the creativity is identifying people who have been wronged or companies that are doing wrong and figuring out solutions to actually introduce that concept in different forms back into the law. And that fundamentally, at least for me, that is that's the mission, the project of the work is to figure out how to leverage the tools that we have to bring justice back into the system. And when I started my kind of plaintiff-side career at Public Justice, and I was kind of a young lawyer, and there was someone there who basically said, look, I said, how do you find cases? How do you decide what to do? And she said, get outraged about something. John said it yesterday, like, get on it. Find the thing that is outrageous, that personally offends you, and then figure out how to attack it and how to go after it. And for Jayne and for Anna and Lauren and David, a lot of the work that they do is ground up litigation, and they identify a problem, and then they figure out how to put a team together, and they figure out how to leverage tools and think creatively about remedies and claims and causes of action. And maybe they don't succeed initially, and over the years, then they figure out how to be successful because they're all dogged and committed. And a lot of the work that we do is figuring out how to deploy the language of the conservative judiciary in ways that can further the interests of plaintiffs and their issues. But what we're all effectively doing is trying to kind of resuscitate this idea of justice. If it doesn't exist in some way within the walls of the building, it definitely exists within the space of the profession that we're all involved in.
So I have a slightly different perspective on this than Matt, and so I want to kind of chime in here just to give you one slightly other view on it. So sitting with the people up here are like really good card counters, right? So if you're sitting down at a blackjack table with them, they're going to tilt the odds in your favor, and they're going to make the outcome much more likely to be successful and much more likely to correct to get what the law can give. But you're still in a casino, and there's still a corporation that controls that casino, and when they find out that you're counting cards, they throw you out. And the law is set up to make sure that the remedies in these cases are not justice. They are set up to be less than what would make someone fall, to be set up to be less than what would change the system. And so we're here to make you excited about the work we do. It's very exciting, but I do think it needs to be, if we want to think about justice, it needs to be joined with something that's outside what the current scope of the law is. Because the current scope of the law can't do that. It's not set up to do that. And that's why when I was talking about you really need to join with people who are thinking differently, changing the frames, because I think that's really how we get to justice. None of this is to detract from the incredibly important work going on. It's to talk about the fact that that work exists within our really biased system, and we don't want to lose sight of the fact that that system exists.
So I'd actually love to build off of that. This conference is being held to discuss corporate capture of the legal system. And I guess the question is, how does the judicial system reify corporate power, and how do you fit into the sort of movement to fight back against that, especially when, as you said a moment ago, David, you are still ultimately card counters who have to be working with other actors as well?
I can start by building really effective private plaintiff firms, in my mind, with the very best legal minds to support those firms. That's to me the way. I mean, I'm working from the bottom up. You know, we're street fighters, and we're working to find justice where we can, but we have to meet those defense firms where they are. And so we find that we have to be equal to the task. We have been, and we will continue to be, but I find in the situation with my firm, I find myself growing larger, even though I come from a small firm originally, and it's a lot more to having a bigger firm. It's a much bigger nut every month to do, but that's what it seems to take to meet the defense firms where they are, to persuade judges that we can take on these cases. When you are in one of these large cases, a mass tort that gets put into a multi-district litigation system in federal court, the judge oversees which plaintiff firms from around the country will be prosecuting that case, and you have to prove that you have the workforce, the legal minds, the track record, and the finances to do that. And that's not really available very often to a 3-person plaintiff firm, regardless of how creative and smart they might be. So I'm just finding that we have to conform a little bit more to the norm to really push our agenda.
I think I have like 3 things that I would say about how to work within the system. First, like, don't take bad cases. Lauren was talking about frivolous cases. We track all of our intake. We turn away 97% of the stuff that comes in the door. Partly because some of those people don't have cases, but partly because the law doesn't recognize some of those issues as things that you can fight in court. And I find myself saying to people all the time, that's so unfair, I'm so sorry, but it's not illegal. So that's one thing. And it's why advocacy organizations and people who are pushing for policy change are so important, and so important for us to support and partner with them. The other thing is that you have to think about what the flip side of your argument is in a way that still gets you your win. And so an example I can think of is I tried a case in 10 or 11 years ago on behalf of cable installers who were not getting paid for every hour that they worked. So like they would get paid $10 if they went and installed like a DVR machine, which was a thing back then. And even if it took them, 12 hours to do it, still $10, right? So we try this case to a jury, and on adverse cross, the company's CEO or CFO admits to how much money they have saved, like millions of dollars, by not paying those wages out. And that, I think, who knows why a jury decides what they decide, but that's so compelling if you think about a company saving money off of the backs of their workers, or you think about the company gaining a competitive edge against other small businesses because they've decided to break the rules. And so everybody who's championing small businesses goes, wait, small businesses need to have a equal playing field also. So that's part of the thinking creative, part of turning the narrative on its head. And again, I could go on forever about how every rule of civil procedure is really messed up, but we don't have time.
I'll go just really briefly. I think, there's a lot to be said, and I think it's quite accurate that the federal judiciary as a whole is, I think, captured by corporate interests. That starts with, the district judges, not all of them, of course, but many of them, and it goes up to the courts of appeal, where you see some circuits that are effectively entirely closed off, are not just populated with, FedSoc corporatists, but are almost entirely controlled by them. And then you've got the Supreme Court. And so, my firm, we've spent a lot of time over the years thinking about how to try to be effective within that space. And I mentioned that earlier, but one thing we have done is we've really tried to learn and learn how to think like a captured corporate judge, and to deploy language and tools that would appeal to them, would try to meet them on their own terms. It's not always effective, but I mean, and I think that I'm not sure I would sound a note of optimism necessarily, but I will say, in the last 3 cases that my firm has handled up at the U.S. Supreme Court over the last 3 years, all 3 of them were cases involving either injured people or a class of workers against major corporate interests. One was against Intel, one was against Southwest Airlines, and the third was against Ford. And in all 3 of those cases, we won unanimously. And in part, that's luck. I've lost cases unanimously at the Supreme Court too, so don't get any ideas. But I think a large part of that is that we've put a lot of effort into trying to think about the kinds of arguments that will appeal to an otherwise, hostile judge or set of judges. And so there's work that needs to be done. I think David is right, outside of the system, but there are ways that we can all be successful within the system if we're thinking hard and strategically about the kinds of cases we're bringing and the kinds of arguments that we're making.
Yeah, I would emphasize David was talking earlier about this kind of the combination of the private bar and the public interest groups that are working together on these. And as I was thinking about this question that you had posed last night, I thought, how many people here have heard of the term forced arbitration? Right? It's basically everybody. Now, if we'd asked that question 10, 12, 15 years ago, I bet it would be 1, 2, maybe 3 people in here. The forced arbitration arc is a great example for me of kind of how the plaintiff's bar has fit into trying to work on this kind of systemic change, because it took lawyers recognizing that this was a problem, and probably, right, some public interest groups who were seeing it and thinking, we've got to figure out how we start addressing this. And you've got lawyers who are fighting through the court system, right, who are taking these cases, who are trying to build records. Sometimes they're getting bad law because it's really bad out there on this subject. Sometimes they're finding ways to right, thread that needle. They find one little, all right, this group, these 4 people don't have to abide by those contracts, but everybody else does. We also needed, but lawyers couldn't be doing that alone, right? The reason that everybody in here just raised their hands about that is because we also had legal writers bringing this to the forefront, making sure that people were starting to hear about the decisions that were coming down and the effect on everyday Americans of having these kinds of pre-dispute forced arbitration clauses in your employment contracts, in your cell phone contract, right? In the addressing, wiping away your civil rights, saying that if your civil rights are violated, you can't use the 7th Amendment. No, that one's not for you. You signed that away when you needed a job. We had legal writers looking at this. We had organizations like Public Justice and AAJ and others who were starting to agitate. They worked with writers at the New York Times to start putting that out there. New York Times did some great stuff about how awful forced arbitration is, and then they stuck a forced arbitration clause in their own subscriber agreement recently. So I canceled my subscription. We had to have people getting the public involved. We had plaintiffs' lawyers who had victims who came forward and told their stories to Congress, right? That's not something that's again, this is a combination of all of these pieces working together, and Congress seeing that at some point, wait a minute, we've got to actually do something about it. And brilliant minds in these organizations thinking, well, wait a minute, maybe we're not going to be able to get everything here. Maybe we're not going to be able to wipe out all of forced arbitration in all of these contracts, but we're going to keep pushing that out there, but maybe we work on the edges. It was at a lobby days for AAJ, for the Women's Caucus, that I attended. I think it was before I had any children, so it was at least 12 years ago, where it was the first time I heard somebody talk about it, and a couple of women decided, you know what, we're going to go talk to one of our representatives, and we're going to get them to introduce a bill. And they got a member to introduce a bill to ban forced arbitration in contracts. And it didn't go very far, but they got him to introduce it in the next Congress, and it didn't go very far. and they got them to introduce in the next Congress. And meanwhile, you've got legal writers who are writing about this, and the public starting to get engaged, and victims going and starting to tell their stories to Congress. And finally, in March of last year, President Biden signed a bill that banned forced arbitration for sexual assault and sexual harassment cases, which was amazing. It's only a piece of what needs to happen, of course, but it's the kind of change that takes a long time. It takes a lot of different people working together. It absolutely takes plaintiffs' lawyers in the mix, but it takes all of the other pieces working together. So, we're just one piece of this counterculture. There are roles for everybody in it. We just encourage you to be part of it.
So I'd actually love to follow up on that. And I know, David, that you wanted to discuss this as well. Do you see your work as simply about ensuring the marginal accountability given existing laws? Or do you see yourself as fundamentally challenging power dynamics and promoting systemic change? Because I think we've sort of talked about how plaintiffs' work can maybe do both. And I'm wondering if you could just sort of, I guess, reckon with like the distinction between the two and how that works.
I think I've spoken a lot about this, so I let others go if they have thoughts, and then I can jump in.
No, sometimes all I do is, get the money back on the couch that didn't work. Something, that fell apart or whatever. I mean, not everything changes. But I will say this, we do have an uphill battle with judges, particularly federal judges, and if you are looking for that kernel of outrage in every single case that you pursue, you actually, like Lauren was talking about, that was the outrage about forced arbitration. And it took a curvy path to get to where you needed to be, and we're still on it. I look at the opioid litigation. I started suing manufacturers of opioids in 2001. I got poured out of so many courts all over the country. Nobody, it was just an untenable situation. Things changed as the epidemic grew, and we were able to get in front of a judge, and that judge could begin to identify with what was happening in his or her community, or what happened to his sister's daughter, or whatever. You begin to build some sort of a relationship, and people get outraged. I remember years ago the Vioxx litigation, which was when Vioxx was a painkiller. Merck had withdrawn it from the market because there were cardiac problems. Overnight, and this is because most of the members of Congress, primarily male, all took Vioxx for tennis elbow and everything else. It was the first case that I experienced federal judges sort of being, wow, like, I don't know about all that other silly stuff you plaintiff lawyers do, but this Vioxx case, wow, like, Merck's gonna give me a heart attack, and suddenly we had that sense of outrage, and we were able to build on it. By the time we got to federal court in the opioids in Cleveland, opioids had no Democrats, had no Republicans, there was no political agenda, because the crisis, the epidemic, was so overwhelming. But we were able to use that to kind of get past what we see in a lot of other kinds of cases, disparity cases, employment cases, sexual harassment cases. There's work to be done in those cases, but you have to look for that outrage. You have to look for that story that's going to get you past. Your court is your jury. You have got to persuade the judge first, and you have to show them why it's impacting their life. And it can take a long time, but we get there.
I think there's another aspect to this that's important too. Yes, so maybe litigation can only go this far. Oftentimes it is very limited, but it's the reason why we need to get out of arbitration. It's the reason why we need to have open records and not court secrecy, which I know public justice is fighting a ton to make sure that court records are open. if you file a public case on the docket and you call a huge publicly traded company, you call them out for wage theft or labor trafficking or harassment, that's public. Maybe the press picks it up. Maybe you're partnering with an organization that AAJ or Public Justice that has a great press arm and sends out press releases. Like, once the customers of that company start hearing these things, they start to rethink their loyalty. And so, yes, litigation, the remedies in litigation are limited, but the impact of reputation, the impact of the story that gets told around the litigation can have a larger impact than just what you win in court.
Well, to jump in with yet a different perspective and take the question a slightly different way, I was really surprised by Senator Whitehouse's answer on Dobbs. Whoever asked that question, it was a great question. I was very surprised that he disclaimed any sense of connection between gender bias that the Supreme Court demonstrated and corporate control. And I guess to use my own work, which I can speak to more authoritatively as an example, so when I think about ag, which is where I focus, right? Ag concentration of power in the United States started in slavery. And today, you see a lot of the same ideas of how you can abuse and take advantage of the body, and particularly of bodies of color, and how meatpacking workers are treated, how farm workers are treated. And so in terms of thinking about systemic change, we've been talking a lot about corporations. And what I guess I would encourage you to think about is that the corporate power in the United States comes from a lot of places that are biased not just about money, but biased based on race, biased based on gender. And that doesn't mean that every corporate case you take is going to be a race-based case. And I don't want you to start going out and claiming that. But I do think a lot of what I think is really satisfying in our work is that what we're seeing today is a concentration of power in corporations that really is an expression of a lot of the ills in the United States, and that's a way that makes a lot of the litigation yet more satisfying.
So I think we have time for one more question. But before we get to that question, I think I would be remiss if I didn't put in a quick plug for the Harvard Plaintiffs Law Association. Firstly, if you're a student at this institution, Anna spoke about the importance of community. David spoke about how people on the plaintiff side can be more fun. We're both. Join us, please. If you're at another law school, create a PLA. If one already exists, please join that. Also, reach out to us. We're starting to build a network. We're already connected with plaintiffs' law associations, Berkeley, Stanford, UT. We can work together, we can find a way to create a culture change, and finally that brings me to the lawyers in the room who stood up earlier. Our goal is to create a culture change, not just to help the students we have right now get into positions at different firms. 70% of students at this institution end up in big law. That number can go down, that number needs to go down, and we think it will go down, but we can't sort of just produce that on our own. Become a mentor. Speak to students. I know everyone said that they were willing to do that. Please do it. We're always growing our alumni mentorship network. I know that other institutions are as well. Sponsor organizations like ours, especially sponsor affinity groups. There isn't enough diversity on the plaintiff side, but we can sort of build that out if we start by working with different affinity groups on campus. And then finally, just try and find creative ways to sort of help out, to like hire younger attorneys, to train them, to develop them, because I think we've seen that the change is starting to happen on campus, and we want to build and develop on it and not sort of just let it go to waste. And in that vein, I wanted to ask the last question, which is, what advice would you give law school students debating a future career between a plaintiff side firm and a big law firm?
Well, first, Molly Coleman is in the back of the room, and People's Parity Project has law school chapters. You should talk to her about that because it is completely aligned with what Pranaya was just talking about. My advice is figure out what you want to do. Like, what is it that you are passionate about? What is it that you want to make change doing? And also, like, the technical aspect of it. Do you want to learn to litigate? Like, you know, there's a place for people to do document review for the first 3 years of their career, and there are places like mine where I'm going to have you go take a deposition because there's enough work for you to do that, and it makes you a better lawyer. So I will turn it to you.
Go.
Yeah, I couldn't agree more with Anna. I mean, it's really a question about what you want to see your professional career look like. And in my experience, you know, if you have a fire burning in you to do good work, and my guess is that everybody in this room does, you want your feet to the fire. You want to get out there and you really want to start doing it. And there is this like, you know, the big law sells you on this idea that you'll get good training. And I can't tell you the number of, you know, law students I talk to who say, well, but, you know, I want to get the training. And it's not true. I mean, I was at, you know, a corporate defense firm and I did things, but I didn't really learn how to be a lawyer. And I remember, I'll never forget this. I helped prepare a mid-level partner who was maybe 44 or 45 at the time for his first argument. He'd been at the firm for more than a decade, and it was his first argument. And it was, oh, this is a really big deal. We got to spend hours prepping. I was like, yeah, really. But then I remember thinking to myself, I do not want to be 10 years into my career without having had an opportunity to get my feet into the fire. And I think if you have that, if you have that desire, if you're ready to go, if you want to do things, then it isn't really a debate, to me at least. You know, there are ways you can do that right out of the gate, before you clerk, after you clerk, if you don't clerk, and it really doesn't start with, oh, the training you're going to get for a couple years at some corporate defense firm.
Well, I'll just underscore what Matt and I were saying at the opening, which is, I think boils down to, it'll be okay. That there are lots of options in your career. I don't know where my career is going, but I hope there are lots of different things that are going to happen to me over the years. And, you know, if you're interested in this work or want to talk about it, whether you're a month away from graduation, 2 years away from graduation, or 4 years or 5 years afterwards, like, we're here to talk about it. And there will be ways for you to figure your way in and out of various different things. And so no path is set in stone.
I would second that. You can move. You can try things out. Maybe you think you want to be a trial lawyer, but really your thing is more appellate work and think tank type work. You can move around. It's really not that difficult, especially in the first 5 years or so, and see what's happening. But there are plaintiff firms out there that are hiring. It just takes a little bit more work to find them because they're not coming to campus and recruiting.
All right, I'm going to do a variation on the three things that I said last night, but in abbreviated form. First, just echoes what everybody else up here has said. You can be creative on this side. You're destructive on the other side. Do you want to create, or do you want to poke holes in something and make it collapse? That's just a fundamental thing. If you want to create, this is the side for you. Second is that you've got to use your voice. People have talked up here about getting outraged about something. Yeah, get outraged and then do something about it. That's what we do on this side. So again, if you get outraged, you think you want to do something, and outraged about real things, right? Work on this side. But finally, there really is a community on this side. There are a lot of plaintiffs' lawyers. We are outnumbered. We're outnumbered in these cases, but as somebody said, we out-lawyer the other side. But there is a vast, deep community of people who are justice-minded, who are doing important work. We are wacky and creative and fun, and you should join us.
And on that note, I think I can speak for the collective that we're so incredibly grateful that all of you could be here And we'd just like to thank you so much for your time and just the time and the effort you took to really speak with us and to also network with so many students over the last few days. So thank you.